For those that don't know me, my name is Jeff Oberl. I am the Training and Development Manager for Cadden Community Management. We are joined today by Jason Smith of Smith & Walmsley. And I'll do a quick introduction of Jason here shortly, but just want to go over a little bit parameters for tonight. So tonight's going to be a presentation style. You'll notice that everybody is muted, but you are welcome to use the chat if you have questions or input along the way, or you can use the raise your hand icon and I can unmute you to participate throughout the evening. So let me give a quick introduction of Jason, and then I will turn the meeting over to him to go over some scary stories from the HOA world. All right, so Jason has been a real estate attorney and litigator since 2001 and primarily practicing community association law since 2006. He began his association law practice as a defense attorney, handling insurance defense litigation, administrative hearings, and fair housing disputes. He has since expanded his practice to all areas of community association law, including general counsel, corporate governance, assessment collections, and construction defects. He also provides services in other real estate matters and employment and injury law. Jason frequently teaches on community association law to other lawyers and to the management industry. He has taught fair housing at the CAI National Law Conference, as well as at the Texas State Bar Advanced Property Owners Association Law Certificate course. He was awarded the Instructor of the Year from the Arizona Association of Community Managers for teaching numerous credentialing classes for community managers, which I attended quite a few. Outside of the office, Jason is an outdoor enthusiast. He likes to trail run, hike, bike, backpack, camp, and white water raft and kayak in the desert and mountains of Arizona and Southwest that drew him here in the first place. When he can't get away, he enjoys sitting on the porch and enjoying the beautiful Sonoran Desert with his wife and 4 children. As a Hoosier by birth, he is also an avid basketball fan. Sorry for stumbling over some of that, Jason. I'll let you introduce yourself a little bit better than I did and turn the meeting over to you.
No, that's great. Thank you very much, Jeff. And I am very excited. The basketball season's finally upon us, but college ball tips off next week. Something else is happening next week that everyone's talking about, but college basketball starts next week. That's all I care about. All right. Well, thank you to all of you that are joining us this evening. As Jeff said, feel free to raise your hand so he could unmute you or put questions or comments in the chat box. I'm happy to have this be more conversational. This isn't a particularly lecturing kind of presentation. It's really about some scary stories, but I hope it spawns some discussion and some thought-provoking input from some of you. So without further ado, let me talk about some things that I think as I started to prepare for this presentation, like what would be scary sitting in your situation. And I've been there before on the board. These, at least the first 4, are things that jumped out at me that would give me concern. Personal financial liability, or even, I suppose, being named in a lawsuit or legal complaint. It does happen sometimes that individuals get named, and that certainly feels beyond what you might expect when you raised your hand and volunteered to serve the community. Substantial extra time invested beyond your usual commitment to read the board packet and prepare and attend board meetings. Sometimes, especially when there are legal disputes, there may be a tremendous amount of additional time that board members have to put in, and that's not necessarily what you signed up for. The next 2 are really, truly dark, scary, and real. Harassment by residents. This comes in all kinds of varieties. Mostly, the harmless sort of lots of emails, phone calls, or pestering you with questions when you're walking the dog in the morning, sort of thing. But it can go overboard at times. And it might, in fact, lead into this fourth category of violence in the community. And certainly brandishing weapons, threatening violence with weapons has been, sadly, a part of association life, even here in Tucson. And we'll talk about some of those stories later on. But I'm wondering if those of you participating, is there anything else that comes to mind that you would say disturbs you or gives you sleepless nights when you think about what might happen when you're on the board? If anyone has any comments, feel free to chime in. I'll give you a second if you want to weigh in before we move on. Anyone? All right, hearing none, let's get into the nitty gritty of some of these stories. So the first story in this, when Jeff first asked me about doing a horror stories presentation, this was absolutely the first story that came to mind, and it lasted over a couple of years, and in some ways it'll be hard to give you a full flavor of the crazy that was involved with this. But I'm going to call this a horror story, The Gonzo Owner. And simply it started with a bit of metal decoration that the owner put on his house without approval. He also put spotlights on it, which didn't help. And the house was situated on a slight rise or hill at the entrance to this um, uh, private gated community of custom homes. The board did not like it, but the board did not, they weren't overbearing or anything, but they did send the owner a violation notice, which he ignored, and they sent him fine letters, which he ignored, and the fine started to increase, but not ridiculously. And rather than ever communicating with the board, trying to work it out, maybe if he had taken the lights off, maybe the board would have lived with it, but he didn't do any of that. What he did was file a lawsuit. So he initiated the battle here. He represented himself, which is part of the horror story if you end up in court, because if the owner is not paying an attorney, they don't have the financial incentive to make it go away. They don't feel that pain. This guy did have money. He could have paid for an attorney, but he didn't. And he filed lots of crazy filings. Everything that was submitted to the court was, dozens, if not hundreds of pages. If any of you know what a sovereign citizen is, people who think that they are not subject to the laws of the United States, he was sort of a half-baked sovereign citizen. And, he would file things with the court with baby footprints on it, saying that he was, not of this country. The law of the sea applied to him and all sorts of ridiculous things. But the story in one basic part, which we didn't understand very well at the time because there was so much paper, so much noise, so much that was incomprehensible in a way. But the guy's strategy, when you cut to the chase of it, he felt that if the board could just impose these fines, like they created their own law, the law of the association, well, he was going to do the same thing. He created his own law and sent letters to the association and board members threatening essentially to fine them. And he thought that that was just as valid as the association having levied fines against him. Well, what it turns out, this is one of the most evil genius tricks. he sent those letters over and over to the board members personally, um, claiming, I think each time it was $10,000 or $50,000 that they owed him. And we, of course, didn't respond because it was nonsense. This guy went to the US bankruptcy court and put all of the directors into an involuntary bankruptcy. They had their credit cards frozen, some of them had bank accounts frozen, and had no idea this was coming. And still, one of the most shocking sort of twists that an owner has ever done in my experience. But imagine you're at the grocery store and you can't check out because your cards are being declined because some owner in the neighborhood was wily enough to put you into bankruptcy. If you didn't know it could be done, now you do. Creditors do have a right to force people into bankruptcy that aren't paying their bills. Now, these weren't legitimate bills. The bankruptcy claims were dismissed, and the owner got slapped around handily by the bankruptcy judge for having done this. But that doesn't take away the fact that those directors not only had some financial stress, and they certainly had this bankruptcy filing on their credit reports. I don't know how that ultimately got cleared up for any of them. But that was just a bizarre twist. It went on for an extended period of time, as I said, maybe a couple of years in state court and in the bankruptcy court. He filed all sorts of criminal complaints against board members. He filed a criminal complaint against me for allegedly assaulting him with spittle when I angrily told him in the bankruptcy court what a ridiculous thing he had done. But he filed a police report for that, and of course, filed a bar complaint. At the end of the day, though, this was a lot of noise with no substance. The judge held him in contempt of court at one point and had court-imposed fines racking up, ended up with a judgment against him for about $120,000, half of which was court-imposed fines. And the good news for the association is they hadn't paid the defense costs. They had insurance. Insurance, I'll preview as a horror story later on, but at the time they had insurance, paying the legal fees. We were able to collect the entire $120,000 because this guy's poor wife, unbeknownst to her, he was doing all this stuff. He owned a food truck, which we had seized and threatened to sell, and voila, $120,000 showed up to pay the association and make the case finally go away. So it was still a horror story for a couple of years, even though it kind of ended on a positive note for the association. Each of these stories is going to have a cautionary ending to it. And what is the cautionary lesson here? Unfortunately, nothing. There isn't anything that the association could have done to have prevented this from happening. You don't always know who your neighbors are. You don't have a right to control who your neighbors are. Some housing cooperatives get to vet and approve residents in their communities, but for the most part, we don't. We take the neighbors as we find them, and sometimes they're going to be gonzo. You can't simply ignore your CC&Rs and not take any enforcement action for fear that an owner might behave like this. But it's out there, and it is a common thread. I don't have reason to think that this guy had serious mental health issues, but he certainly was not behaving rationally. And we were not the only people tangling with him at the time. He had sued Jamie Dimon personally, the head of Bank of America. So, I mean, there was really no bounds for this guy at the time. He had half a dozen crazy lawsuits like that going. And somewhere he's found peace and quiet because He's not causing trouble for people anymore, as far as I know. And maybe his wife put him in the corner after almost losing her food truck. All right. Uh, c- Horror story number 2. I call this one the martyr. This has a sort of a terrible ending all around. Um, a tree, a kingdom for my kingdom for a tree. Line from Richard III. Not necessarily that relevant here, but it is what came to mind when I thought about this poor guy in this tree. Um, this is a story about uh, preserving desert vegetation or not. The owner in this case, this was an air park, and the runways these are large lots. The runways were on easements that go across the lots. And so you've got, a couple dozen owners that have runway easements on their property. Um, and for decades, since this community had been developed, they had not been doing a good job maintaining the runway easement. There was a strip of paved runway, but then there were 70 or 80 feet on either side of it that were also runway that were not improved but had not been bladed or cleared with any regularity for decades. And it was becoming overgrown. The board thought it was a hazard, and they approved a plan to start clearing the vegetation. Well, this owner did not take kindly to that. He had some barrel cactus and some volunteer mesquites that had grown up. These were not things that he had planted himself and invested money in, but they were on his lot, and he was absolutely incensed that the association was going to level this part of the lot and remove the vegetation under the idea that it would be safer for the residents and visitors if their planes, veered off the paved runway. And these standards, the area which they were clearing was standard width for the FAA for air parks. But the association hadn't done anything about this in decades. And I can see in some ways why the owner was like, well, why are you doing this now? You haven't cared about this. I like this vegetation. It makes my home more valuable. It makes me feel happier in the desert. And he sued the association to stop them from clearing the brush, not just on his lot, but anywhere along the airstrip. And he was able to win at the trial court, and the association, and myself included, uh, I was just in disbelief that the court would say the association couldn't maintain its property for a safety purpose, right? This isn't just aesthetics. This was a life and safety issue. It seems unquestionable to me. They went up on appeal, and the Court of Appeals agreed with the trial court and said, well, you guys hadn't done anything in all these years. You can't really just start doing this without the owner's consent to clear vegetation on their property. And the association did have insurance, so they didn't pay a lot to put up with this fight. The insurance company ended up paying the homeowner about $180,000 out of the $300,000 that homeowner incurred. So even though that was painful and the insurance company paid that, that owner still was out of pocket $120,000 to save some barrel cactus and some volunteer mesquites. And so I still am in disbelief that the courts ignored this safety issue and treated it like just some rogue HOA being petty about landscaping. Um, and so the end, though, isn't necessarily scary for the board, but maybe it is. About a year after this case was over, the plaintiff, in this case, the owner that sued, had his plane veer off the runway, hit a tree, and was killed. Now, we don't know. The rumor is, what I heard was the tree that he ultimately hit might not have been removed in the maintenance of the runway, but it does go to show that there was a legitimate safety issue, and the courts simply ignored it, and this owner simply ignored it and preferred to have the vegetation and take the risk, and he may have paid for it with his life at the end. So really, not a great story. What is the lesson to be learned from this? A little tongue in cheek, don't delay maintaining your landscaping, perhaps. It's never too late to do the job you're supposed to do. It seemed in this case that the court said, well, you've blown it, you can't do it anymore. Again, ridiculous. The other cautionary lesson here is going to court's a gamble. It shouldn't be. It doesn't have to be. Most of the time, it's not. We have tried and true processes in court, and we usually have a good sense of how something's going to go, but sometimes we just don't. And I will scratch my head until I go to the grave over this story that both the trial court and the Court of Appeals just didn't think that airport, essentially runway airport safety, was that important for that association. All right. Any questions, Jeff? Or we're doing nothing going on yet?
So far, so good. So just a reminder, you can use the chat, or if you have some input or questions, feel free to use that raise your hand icon on the bottom of your screen, and I can unmute you.
All right. Again, happy to take questions if you've got them, or comments. Horror story number 3, lions, tigers, and snakes. Oh my. My daughter was not very happy about this. She was like, Dad, it's bears. It's bears. I'm like, okay, creative license. It's about snakes. And it's the night before Halloween. We're trying to be scary. It's about snakes. Lots of snakes. This, though, is Florida, not Arizona. Some of you may have heard this story a few years back, but it was a condo or townhome in somewhere in Florida, and the common area, or the center, or part of the center of the community, was a swampy area, a marsh, sort of a wild space. Think about our open space desert areas in some of our communities. So kind of like that. And it had its more than its fair share of water moccasins, apparently. And resident opened the slider on her back patio and stepped out and got bit on the toe by a water moccasin. Much to her surprise, sadly, part of her leg had to be amputated because of the bite. And she sued the association. Even though it was wildlife, it happens, right? She sued the association, reportedly settled for $5 million for the loss of her leg, and had presented evidence that it was 8.6 times more likely to encounter a water moccasin there in, the Shady Acres HOA, whatever it was called there in Florida, than to have encountered a water moccasin in the Everglades. I suppose part of this may be that there weren't natural predators for the snakes in this somewhat domesticated space. The board knew about the snakes, though, and apparently even talked about them at times at board meetings. I don't know if their mindset was like ours often are here in the desert, of, well, that's wildlife, that's nature, we know about it, no big deal. That's just part of living in the desert, or in this case, the swamp. But this wasn't your average risk of being bitten by a snake, right? 8.6 times more likely to encounter the water moccasin. They were, I guess not running amok, but slithering amok. They were everywhere in the community. The board knew about it. The board didn't even bother to warn people about the snakes. And so I don't think that here in Arizona, this question does come up now and then where owners complain about potential snakes in the wash behind the house or something like that. And my advice, my standard advice is, and you probably hear this from management, you probably think this yourself, which is we live in the desert. This is a known risk. It's not an association problem. And that usually is the correct answer. But if you happen to know that there is an especially high risk and unusual congregation of snakes or coyotes or something like that, then you do have at least an obligation to warn the residents about wildlife. I suppose it doesn't hurt if you have a newsletter or website to occasionally make note of that for people, just as a risk mitigation measure. I don't think it's necessary, but it might have saved that association millions of dollars had they at least done something to warn the residents. And after they paid the $5 million, part of the settlement was they did, in fact, put up signs in the community warning people about the presence of water moccasins. So if you know there's a greater risk, yes, you do have an obligation to keep your common area safe, or even in this case, it was on the woman's property, but the snakes were coming off of the common area. So if you love snakes, this is a story for you.
And Jason, I
Uh,
know I've had instances where we've had reports of, a mountain lion was sighted in the community or a bear, in an instance. And, of course, it was nature, but we sent out a notice to the entire community of the report. So at least we could put them on alert of what we knew.
right. And I mean, it is one of the benefits of having the infrastructure in place, having management, having the website or social media, perhaps, or whatever methods you have to communicate with the membership. If it's as easy as, typing a few sentences and hitting send, why not do it as being a good neighbor as well as sort of mitigating the association's risk? And yeah, I mean, Nextdoor and some other places do provide some of that, but it certainly is more